and welcome to the Romanov's Family Law channel. Today I would like to talk about basics because I ended up repeating the same principles 3 different times for approximately 3 hours today with 3 different clients. So I decided to create this video because it will explain a little bit about California law, what separate property is, about terminology, about basic rights. And this will not constitute a legal advice. Please take it or leave it. This is my experience, how I perceive family law. And I practice family law in San Francisco. I just passed the Certified Family Law Specialist exam. I feel confident to do this video, so I hope it helps. Let's get started. All right, so first principle that I tell my clients when they come to my office and asking questions about divorce: what was the date of marriage? The date of marriage is important because it's the point where community property starts accumulating. The second part is, what is the date of separation? Date of separation has been litigated in the last couple of years. There was a case of appeal that was reversed. In any case, date of separation, to simplify it, is when one party either moves out or doesn't move out, but there is a clear understanding that one party expresses, I do not want to be together. It's called irreconcilable differences arise, meaning we don't want to be together and it's irreversible. So let's say date of marriage is 1/1/2000 and date of separation is 1/1/2010, just for the purposes of this conversation today. So we'll look at anything that both parties brought into the marriage. It's called separate property. So let's say I had my separate bank account, my car, whatever. So that's remains my separate property, meaning it does not become part of community property. There are little exceptions out there. I'll tell you about them later. Or not exceptions, actually, diversion of that. And the same for the other partner. So, and then on the date of marriage, whatever is accumulated through personal skill set is called community property and is divided 50-50. And for example, let's say, to simplify things, I have a tree, and that tree could be considered as a bank account, retirement, house, anything. And that tree produces apples. So if the tree produces apple and the tree is separate property, the apples would be separate property. Now, during the marriage, I water the tree. And not only I water the tree, my husband improves on the house that I purchased. Let's say I purchased the house here, I have my name on it, and we all live in that house. I put down payment, I'm paying mortgage payments, and he pays mortgage payments. And that's where the diversion here happens. Technically, the house is separate property house, but because I'm investing and my husband is investing personal skill set and paying mortgage from a salary, that becomes somewhat, depending on the amount of years, which would be helpful CPAs to figure out how much community property the house will eaten up by community. So if it's 40 years and I paid for the house $200,000, then code section 20, anyway, I'm not going to hold myself accountable to the code section, but one code section says I get my $200,000 back, dollar for dollar, and the rest is eaten up by the community. If I didn't pay the down payment, mortgage payments here, I just paid down payment. All right, so that's the basic principle. Then the second part, so I say to my clients, the topics we're going to discuss is property division, spousal support, child support, child custody, and how divorce process works, how much it costs, and what about attorney's fees. So these are the topics that we're going to talk about. I covered a little bit of the property division so that you know the basic principle. And again, we have date of marriage, date of separation. What about retirement accounts? Let's say I married with 0 and then I started earning and putting into retirement. What do you think will happen? I don't have much time probably in this video to go into the so-called quadro. I can create a different video on that, but in nutshell, the legislature developed so-called qualified domestic relationship order. Basically, in order to give 50% of the retirement, I cannot just take the money out and cash it out without paying penalty and taxes. Penalty and taxes can be very high. Don't hold me to the number, but they're high. I don't know exactly the number. So let's say the legislation developed that spouses who are going through divorce, in order to avoid to pay taxes and penalties, they create so-called quadro. And we lawyers usually hire a firm, Madden and Schwartz, for example, who creates for $600 a quadro order that we submit to the court and then submit to the pension provider, who it's called rolled over the pension to, let's say, husband's account. And that's developed, and again, it ends right here. Versus house, if we still own the house, we don't evaluate the house as of date of separation, we evaluate the house as of the date of trial, unless agreed otherwise. Why? Because from that date, I always recommend my clients to open their own separate bank account from the date of separation in order to avoid double dipping. Always open your separate bank account. Again, this is not legal advice, but what I recommend, so that the separate money, separate income goes into that account and is not becoming 50% of, you don't need to divide this to 50%, so you just keep it. And the same with retirement. When you separate, money you earn doesn't become the money that is going to be in the pool of 50-50. So, but the house is going in value up and up without you doing anything. So that's why the house is evaluated at the date of trial. There are other topics like stock options, RSUs, and how to deal with houses. Do I sell? Do I buy my spouse out? All of these issues are case specific, and I'm not going to go into them here in this video. So I will go forward with spousal support. Spousal support, again, we're looking at the date of marriage, and then the date of separation. The law says that if the marriage is longer than 10 years, it's considered as long-term marriage. Why is it important? Because there's another code section that says if the marriage is longer than 10 years, then spousal support can be permanent. Permanent meaning until the receiving spouse dies, remarries, or cohabitates with someone who supports that receiving spouse. Receiving support. You understand what I mean? The spouse who receives support cohabitates with someone who helps with the bills. So let's assume the marriage is not 10 years, the marriage is 8 years. If the marriage is below 10 years, it's considered short-term marriage, and then the spousal support is considered half of the length of the marriage, which would be 4 years. And we have cliche scenario, dad who works, and let's say he earns 100K a year, and mom, stay-home mom, who takes care of the kids, a huge business to take care of the kids. However, financially, let's say she's not working right now and only dad makes money. In this case, it's approximate amount. She will receive 40% of his net income. There are formulas used in court, and there are also online DISA-masters that can be used. It's called DISA-master calculator. If you would like to know the numbers, just go on Google and say California Child Support Calculator, and then there will be a free software. Then when you scroll down to the very bottom, you will find temporary spousal support. And if you're, let's say, in Santa Clara, then you click Santa Clara and then it will calculate. And then you can see a lot of things are going to be deductible, like mandatory retirement, things that are mandatory. You can't say, oh, my house is so expensive, I'm spending $10,000, I cannot pay child support. That doesn't work. So you can see what is actually deductible. And there are two ways that spousal support is defined. One is temporary spousal support, and one is permanent spousal support. As the word temporary suggests, it's only temporary for the time being while divorce is pending, meaning divorce can be pending in court for years. My clients usually ask me, how long does divorce take usually? I would say in a regular average case without big drama, around 9 months. So for the time being, based on the calculation, based on the DISA-master, and during divorce, that's how support is calculated. Then we have permanent support. Permanent support is after divorce is final, and it's based on so-called 4320 factor of 4320 factors family code section. There are 20 factors. I'm going to talk about only 3. Standard of living, a need of receiving party, and ability of paying party to pay. Standard of living is based on, how do you base standard of living? You just look at your tax returns of your expenses for the last 5 years, and that's easy to establish standard of living. Versus here, let's say if husband earns $1 million, but here for the last 5 years he earned only 100K, then the expectation to receive spousal support here is different. It's just based on DISA-master calculator, 40% or 37% or something like that, if there are no children. And here, if you look, the average was this number, and the needs are still reasonable, then it's going to be completely different number here. And then I talked already about the termination of spousal support. Spousal support can be terminated whether with an agreement, or, for example, in long-term marriage, the nightmare of some people is when spousal support doesn't get terminated, when long-term marriage and then the court reserves jurisdiction over lifetime. So when you do negotiations, maybe pay attention to ask that the other spouse who is self-supporting agrees in a long-term marriage to terminate spousal support forever and to terminate court's jurisdiction to talk about this issue forever in exchange for a lump sum. So that gives a little bit insurance to not have to deal with it. Let's say if a spouse becomes disabled 10 years from now and ask for spousal support and you have already a family, you would like to avoid that. Again, there are more details about spousal support that I might have to create a different video. For example, if husband says, you know what, I don't want to pay you spousal support, I'm gonna stop working, then, and he earns $200,000 and now he's not working and living in Mexico with his new girlfriend, well, what do? You file and ask for imputation of his income, meaning you ask the court to impute to the level that he used to earn because he voluntarily stopped paying in order to avoid paying you spousal support. And the court has authority to do that. There are some burden of proofs that needs to be shown that he did it not voluntarily, and then it shifts to him to prove it. That anyway, I'm not going to go into details, but that's something to pay attention. Or if, let's say, wife was for 5 years employed, and then she decided not to be employed and became freelance, but she has the ability to earn a lot of money, then you have the opportunity to ask the court to get vocational evaluator to look at her ability to work on the market and how much money she would receive, and that way the court would have the authority to impute the income. So there was a lot of shortcut about spousal support. I'm going to move on. Child support and child custody. All right, so child custody is more important because child custody and visitation will lead to how much support the spouse will get. Child custody is based on terminology solo, joint, and then legal and physical. I gotta give this example out of my way. I get so many clients call me on the phone, they don't know me, and they call me up and they say, Diana, my husband cheated on me. I need to file for solo custody. I want him to not see our children at all. This is it. I want to do that. So, and I always say the same thing. It's whatever is going on. First of all, California is a not fault state. So what he did, I'm sorry you had to experience that, but it has nothing to do with the topic of child custody. So in order to get solo custody, it has to be very significant, very significant attack on personality, on the person, being abusive, not just emotionally, physically, drug addiction. We're talking about high level and being unfit to be a parent. So moving on. That being said, solo legal custody and physical custody is awarded in rare cases of the cases I described. Joint means both parents. Solo means just one parent. Physical means where the child resides most of the time. And legal means who makes the major decisions about child's life. And usually, in 99% of the cases, it's awarded to both parents. And if the child is very little, or typically, it's cliche again, but it's happening all the time, that mother stays with, let's say, a newborn baby and father sees every other weekend, solo is awarded to mother because that's the primary residence of the child. So some people call it full custody, but the real term is solo, and then it's called 50-50 custody. Now, 50-50 custody has nothing to do with visitation. You can have 50-50 custody, but 10% visitation. How is that? Well, visitation is the percentage of time you spend with your child. And if you're unaware how to calculate percentage, I would be too. It's math. Just go online and Google again child support calculator California, and then find that calculator, and then there will be on top percentage spent with parent one, and then you will find that number. And if you click on advanced, there will be a whole line of calculations that you can manually put in. For example, every other weekend might turn out to be 17%, and then below you can put 2 weeks in in 3 months, and in a quarter, we'll put you in a percentage. So remember, 50-50 custody has nothing to do with visitation. And then finally, on the child support and custody topic, we are moving on to child support. Child support. There are two different child support topics. One is basic, and another one add-on expenses, adds on. Basic child support is based, what we just discussed, is the percentage. Like if you spend 10% and then the income of each party, of each parent. It's it's based on this semester calculator. So add-ons are childcare. What is childcare? Childcare is, sorry, I'm not writing it clear. Childcare is, for example, babysitter cost. If dad goes to work and needs a babysitter or looking for a job, then childcare costs usually are shared 50-50, unless there is such a disparity in income that it would be unjust to have 50-50 split. The court might consider proportionate to the income split. Then visitation, visits, driving costs for the visitation, and medical expenses, out-of-pocket medicals. And then there are also extracurricular activities. There are lots of other things that both parents can agree to split 50-50, such as school, whatever else on top. But this can be calculated into the semester calculator. All right, moving on to the process and attorney's fees. I can summarize it maybe in a few minutes, hopefully. All right, the process. There are two ways to get divorced. One way is called uncontested. Uncontested means no fight, no court, and another way is contested. Both ways start the same way. Someone has to file a petition. I probably get every week a question about who files first, whether it's beneficial if I file first. It doesn't matter who files first. The only time when it matters who files first, if you live in different state. For example, if I live in California and my husband lives in Germany, then if I want to be divorce handled in California, then I would file in California and serve him through Hague Convention, which is another topic for a different video, to Germany. For example, if I have an amicable divorce and I want to take over the entire case and I want to be in charge, I would file the petition, because if my spouse doesn't respond, they can file a default package. So, well, actually I reverse my answer. It does matter for these reasons. Otherwise, if you both agree that you're gonna end up having an agreement and you both are gonna cooperate and work together, then it doesn't matter. So once the petition is filed, which is together with summons and sometimes with arbitration notice, depending on your county, that needs to be served. Why does it need to be served? Well, service is delivery of paperwork that was filed with a case number that notifies the other party that the case has started. There are 3 ways to serve, which I'm not going to go into this in this video, but once it's served, the clock starts ticking for 6 months and 1 day, where a lot of people would like to be single, but no sooner than 6 months and 1 day from the date of service. And it doesn't happen automatically. I know some people think that after 6 months and 1 day of doing nothing, they will become single. No. I have to break it to you. In California court, nothing happens automatically. Maybe divorce gets dismissed, maybe, I don't know, it never happened to me. But sometimes I could imagine divorce might get dismissed if someone files a petition and doesn't do anything for 10 years. But most of the time, you have to be proactive. If you want to finish this divorce, You need to file a petition. You need to hire someone to serve. It cannot be you. It has to be someone else over 18, ideally professional process server, because if your spouse says, I wasn't served, it is presumed to be served if it's professional process server. Moving on. So in both cases, it's the same. Needs to be served. Then the receiving spouse, this is the petitioner who files the petition. The receiving spouse, it's called respondent. Respondent has 30 days to respond if he or she doesn't like what petition says, to clean up the record. Especially if petition says, I would like to keep all of the accounts in my name and in your name, I would definitely run and file. If the petition says everything to be determined, then it doesn't matter, because it's hard to file a default on something where it's open and to be determined. And then uncontested part can be settled through so-called marital settlement agreement, where you sit down and create a prenuptial agreement, but it's called marital settlement agreement. It's similar to prenuptial agreement, but it's postnuptial agreement, where you have fiduciary duty to disclose to each other all of your assets and settle all of the aspects that we discussed right here in here. If you don't have lawyers, your signatures probably would need to be notarized depending on the county you're in. And then once that's signed, you have to file uncontested or default if he didn't respond. Default was agreement if he responded uncontested package to finalize the divorce, and then the court approves it. Might take 3 to 4 months. Santa Clara takes 1.5 years in some cases that I had. I hope one day it changes, but if you're in Santa Clara, actually, I propose that you hire a private judge to sign off on your paperwork. Marin County is the fastest. It was happening in 2 weeks, literally. All right, so in contested package, we have the same process, and then except it doesn't go away with marital settlement agreement, probably, you can guess, it goes to court. My writing today is very, okay, you know what I mean. So when you end up in court, again, nothing happens automatically. If you would like to get spousal support, attorney's fees, or you would like to establish custody, you have to file a motion. It's called the request for order. It's a form FL 300. And once you file, you get a hearing date. The hearing date is only giving you 20 minutes time. In some counties, recently, most counties adopted it. You get actually a judge to make an order a day before. So if you don't go online and check the docket, you might miss your hearing, and you might arrive and the judge says, too late, I made my order yesterday and you didn't object, so this is the order. So pay attention in what county you're in to go online and see if there is a tentative ruling in order to avoid the order to be in effect. But remember, you get only 20 minutes. So if you file something related to custody, the judge is not going to decide your case about your child in 20 minutes. The court is going to send you to mediator. Mediator is someone who court assigns for both parents. It takes about 3 hours to figure out the schedule. And depending on recommending or not recommending county, the court will adapt the recommendation of the mediator. And then it becomes an order. If you're not satisfied, or if you feel like you have more evidence to show and the court agrees, then you can get a trial date. Trial is something that could take between 2 hours up to, I haven't been involved in that trial, but I heard about a move away trial that took 9 days, where a mother wanted to move away to a different state. So that's the process. And then eventually you can still have an MSA, and if you go to trial, the court in divorce, the court gives, unless it's a domestic violence restraining order case, mandatory settlement conference date, where you get to meet with an attorney. Typically it's a volunteer attorney who has family law specialist exam, who helps to negotiate the case. It's like a buffer. And some courts have also judicial conference settlement. As the word judicial, it suggests it's a judge not related to this case, but the judge who will help to settle this case. And then the third buffer, if 2 buffers are not met, then it goes to trial, no buffer. So that's how it goes. Before I wipe it away, attorney's cost. This package in my firm is costing about $5,000. Uncontested, if it could be less. So $5,000 is based on hourly rate right now, as we speak right now, $395, and we are in October 2019. This package based on that hourly rate, and if that goes smooth, no negotiations, nothing, it might add up $3,500. But typically there are some topics that become very hot and sturdy, and then it depends on the other side's cooperation and how many back and forth. It could be even sometimes 10, because if the other side doesn't have, actually forgotten one thing, it's called PDD, Preliminary Declaration of Disclosure. In both cases, it's mandatory to exchange financial disclosures. Sometimes it becomes an issue where we have to send discovery requests, subpoenas to banks. We have to gather all the documents. The other party is so busy, they don't want to respond to anything. That might raise the fees. This part can become so uncontrollable. Anyway, I'll start with 10. I know a firm who charged $267,000, not my firm. My firm so far, $80,000 in a high litigation, custody, businesses, everything was litigated. Literally, even the issue which real estate person we're going to choose has been litigated. It was crazy. So that was so far the highest amount. We talked about that, cost. All right, attorney's fees. I'm going to wrap it up with attorney's fees, because I'm sure you're curious to know how it works. And in civil law, you could say the prevailing party has to pay receives attorney's fees. In family law, it's not like that. In family law, there is no prevailing party. It's about children, it's about dividing assets. There is no win, actually. In family law, there are 2 ways of getting attorney's fees. I'm simplifying it. There are many other ways about discovery, code sections. I'm not going to talk about this. It's need-based and sanctions. For some reason, most people don't know what sanctions is. Sanctions is like penalty. If you misbehave, you have to pay. Or it's called, in a lawyer language, 271 sanction. If you Google Family Code Section 271, you can read what kind of misbehavior is sanctionable. And then need-based. In our example, husband earns 100,000, wife earns 0. He has to pay attorney's fees, maybe $5,000. The point is, the spouse who doesn't have the money needs to have equal representation rights to ask for support, to file motions. You saw how complicated that can get about being proactive and serving and all the little details about discovery. So that's when wife comes to the office and says, he has access to all of the assets and we have $5 million. What do? I have literally, he gives me credit card and he closed it, and now he gives me allowance of $2,000 a week or something. That's where typically either my law office, or depending if I'm on the other side, they receive this spousal support and attorney's fees, so that they can say, we need to hire a CPA, we need to divide the assets, we need to go into discovery. That's completing our session today. I hope that was not too long.